Welcome back. Setting aside their death sentences, Allahabad High Court on Monday had acquitted Nithari killing's prime accused Surendra Koli and Moninder Singh Pandher, saying the prosecution failed to prove their guilt. This case had shocked the country 17 years ago, and now it has shocked one and all again with this acquittal, leaving the question in everybody's minds: what about those skulls and skeletons that were found? Who killed those victims? This case is related, remember, to the murder of a 20-year-old woman who was reported missing in October 2006. The killings had led to the recovery of skeletons and belongings of missing girls from a drain outside businessman Pandher's residence in Nithari village bordering Delhi in December 2006. Koli, the other accused, used to work as a domestic help and lived in Pandher's residence. Now, this is what the court has said while acquitting the duo of almost all charges and cases. The court has lashed out at the failure to comply with requirements of recording confessions. So, this has been a case absolutely against the prosecution. Disclosure statement was full of contradictions. The court also said that the statement by sole prosecution witness was unreliable. 16 FIRs lodged against Koli was not convincing. Accused has also alleged torture by the probing agencies in this case. No independent corroboration of murder, rape and cannibalism, all the charges that were made in this case. Events mentioned in confession, quote, are highly improbable is what the court had said. The possible angle of organ trade was not even investigated properly, and the court lamented that important aspects of the case have been dealt in a disheartening manner. So what happens to the duo now? Here is more. Surendra Koli was acquitted in 15 of the 16 cases against him. In the remaining case, he is already serving a life sentence and he will continue to be in Ghaziabad prison for that sentence. Moninder Pandher, on the other hand, had initially been named in 6 cases. He had already been acquitted in 4 cases earlier, and now he has been acquitted in the remaining 2 cases as well. So he is all set to be released from the Noida jail soon. The big question we're asking is, 17 years on, exactly who killed those 18 victims and where are those answers going to come from? Let's go across to the guest joining us. Manisha Bhandari is Moninder Singh Pandher's lawyer. Sumit Chander is advocate Supreme Court, and Dr. Vikram Singh, former DGP of Uttar Pradesh, is also joining us. I do thank you for your time. Dr. Vikram Singh, I'm coming to you first. This is quite an indictment of the police in this case. The verdict is such a horror for the police and the investigating agencies to read.
Shivani, you're absolutely right. The High Court verdict needs to be inquired deeply as to where the fault lines lies. The prosecution, I would say that the prosecution failed in its duty to make a convincing case in the High Court, whereas the CBI trial court, the High Court and the Supreme Court had already convicted both of them. In the backdrop of this development, to get this kind of a judgment, I respect the Honorable High Court, but yes, the inquiry needs to be done on the basis of what shoddy prosecution and what flaws in the investigations were there. The High Court has pointed out several horrible fault lines in the investigation. The confession extracted, not recoveries. It is unconvincing a case. I agree. Cannibalism is the rarest of the rare case. And in my own lifetime, this is the only case of cannibalism. But there always has to be a first time, and it has to be investigated as such. The CBI sent the Interpol, and only South Africa exerted and said that this was one case. But on the fact of it, the harsh remarks by the Honorable High Court needs to be investigated, that once you have a conviction by the trial court, the High Court, the Supreme Court, and to have this kind of an embarrassment, well, this calls for a deep inquiry and heads should roll.
Yes. In fact, the court has said in its order, and I quote, inferences of many kinds, including collusion, etc., are probable on account of such serious lapses occasioned during investigation. However, we do not intend to express any definitive opinion on these aspects and leave such issues to be examined at an appropriate level. Sumit Chander, don't you think there should be some accountability of what exactly happened here, as Dr. Vikram Singh is saying?
Absolutely, there needs to be an accountability. In fact, if you look at what has happened, though there was a confession recorded in this case, this confession was recorded after about 60 days of remand. Why did it take so much of time? And if you look at why the High Court had granted the acquittal, it was basically on procedural aspects. One of the important procedures is that a statement is to be recorded before the magistrate under section 164. That statement itself was not recorded. and if it was recorded, it was not signed by the accused. Now, signing by the accused and the magistrate on that statement is absolutely important in law as per section 281 of the CRPC. Besides that, the confession was made in a video, they say. Now, the transcript of the video is also to be signed by the magistrate as well as the accused, which also I'm told that in this case, as per the judgment, it was not done. So these are those various minute practical aspects, the procedural aspects.
But the court has acquitted them in virtually all cases, not just because of procedural lapses, but also because the prosecution failed to establish guilt without reasonable doubt. What do you think happened there?
See, guilt without doubt will have to come only if the statements have been recorded as per the law provided. All the statements cannot just randomly made. In fact, there is a provision in law which says that the police has to ensure, or the magistrate has to ensure, that the statement has not been recorded under torture or duress. In this case, to prove that, the magistrate statement before the magistrate is important, but that was not done in this case.
Okay.
Now, if you look at section 24, I'll just take you to section 24 of the Indian Evidence Act, which says that a confession made by an accused person is irrelevant in criminal proceedings if making of the confession appears to the court to have been caused by any inducement or threat. So the section law is very well settled. The procedural aspects have to be followed.
Let me go across to Manisha Bhandari as well. I'm sure you're looking at this as a big success, but could you in your words describe what this acquittal means for you and your client?
Well, success comes later. You have to understand that this has been a journey, not just looking at the end product. It's been a journey of 17 years of him and us being together. This might be, people might want to condemn it whichever way they want. They've been doing it left, right, center. But please understand that there's something called balance. You cannot just condemn a man because you feel that would be appropriate and right in your own perspective. He has lost 17 years of his life. His son, his wife, his name, his family, everything is gone. For him, just because the sessions judge feels that it is his house and it is his servant, that's about it. That's the circumstance you're talking about. His confession comes later. There are just 3-4 circumstances enumerated by the learned sessions judge, and the same sessions judge acquits me. It's, Mr. DGP, he has said that I stand convicted by the Honorable Apex Court. That's wrong. My first conviction came by the Sessions Court way back in 2009, and 2010 I stand acquitted by the Honorable High Court. After that, the CBI has not gone in appeal, by the way. It is the complainant who's gone in appeal. I am not convicted, neither by High Court nor by the Honorable Apex Court. I stand acquitted by the Sessions Court in 2 cases. So, as on date, this is it's actually not success. It's a moment to understand for everybody that his stand, his family's stand, our stand has been vindicated.
I get that, but do you also believe that the public at large believes that they were not guilty?
There's no question of public believing or not believing. I'm not concerned with that. And why should I be concerned or he be concerned? Please see, public has not read the judgment. Public has not read the evidence. Public has not read the Honorable High Court's judgment. And I'm sure most of us haven't. It's something which I feel I should take a stand that there is injustice. I should stand with the candles.
So you believe your client was completely not guilty. So what are your thoughts on why did the police make them the accused and put all of these cases against them?
The CBI did not. CBI had exonerated Mr. Pandher. There wasn't any charge sheet against him. Everybody knows that. There could not have been, because every time, please understand, the case is that every time the CBI's own cases, every time the house was empty, that's when all this happened, if at all it happened. That their case is not this, that I was at home and both of us hand in gloves did that. The case has never been that. The case of the prosecution was that Mr. Pandher used to leave for his work. because he used to travel a lot, and post that this happened. Now, when
But
you
he had no
read the
knowledge of what was going on.
Can we? If you're traveling 3-4 days in a week and you come back home, there is no one at home except your servant. Can you find out if the servant is staying at the first floor of the house? No one can. The High Court's observation has come very specific that, well, he loved his alcohol. At best, it's a case of debauchery, accepted. But if that be so, would a man who's not in his senses after 6 o'clock in the evening, is drunk, is sleeping, gets up in the morning and leaves for work again, would he know what's happening? Do we actually go and check our servant's room every day? We don't. Nobody does that.
Can I also finally ask you, before I go give a final word to Mr. Vikram Singh as well, what is the reaction of Mr. Pandher after these acquittals? Could you share with us?
But I haven't met him, but of course, he's waiting to get out. Anybody would. The family is relieved.
Okay.
Definitely. Yeah.
Okay.
Relieved.
Vikram Singh, you wanted to come in very quickly, sir. 30 seconds.
Yes, Shivani. 2,000 hearings, 500 witnesses, and of course, multiple cross-examination. As a learned lawyer, Manisha ji has done a commendable job, but the fact of the matter is, none of them got any relief from the High Court or the Supreme Court. In the current case at the High Court, yes, there were horrible mistakes and blunders that were committed, and the evidence was not adequately produced, nor was the prosecution attended to, and that is why you have such adverse remarks from the Honorable High Court. That, of course, is a matter of discussion and debate, and also appeal to the Supreme Court.
Right.
But the underlying factor is the 500 witnesses. Pandher has been charged under 201 of the IPC as also immoral trafficking as well. But Koli has been convicted, and there is multiple evidence. It's a different matter that it was produced. That does not mean that
yes, the case wasn't fought very well. He has, of course, one of his cases still stands and he's serving a life sentence in that. Mr. Pandher, I want to give you the final 30 seconds as well. Now, fundamentally, this is about justice. What happens to the justice of the families who lost their loved ones, young girls and others? What is the way forward for them in this case?
Let's go by the facts. A crime has been committed, arrests have been made. What the High Court in its acquittal, by giving the acquittal, has given in the judgment is that there have been procedural lapses. Now that needs to be seen and taken up. The people the officers in charge have to be taken to task. The matter still can be taken up to the Supreme Court. But end of the day, what remains to be seen is the person or the accused who are guilty of this offense should be punished. How? That is for the investigating agencies to come up and do the proper trials so that the proper accused can be brought to task here.
Yeah.
So that is what needs to be seen. And the law of our country is very simple. In fact, the law of the land says that every person who is accused, let many guilty be gone free.
Yeah, but no one innocent person should be convicted. I get that. In this case, it's very complex because you've got clearly one conviction, so there is some guilt that has been apportioned, but you haven't been able to prove the other cases against that one individual. It could also be the other individual who was the accused for 17 long years, had nothing to do with it, as the court now says. There is both a question of guilt, proving that guilt, and of procedural lapses and more. But fundamentally, the question is, what happens to those families that were seeking justice as far as those deaths and killings are concerned? But I've run out of time. I do thank all of our guests for joining us. One more shocking legal case in many such cases history in the country surely puts a question on the legal judicial system in India. With that, it's a wrap from me. Rahul Shivshankar is joining you with the hard facts on the other side.